Mr. Trush, is Mr. Krueger here?
Yes.
Okay. We'll call People versus Kenneth Krueger. This is file number 256832. If I could have counsel put your appearances on.
Good morning, Your Honor. For the record, like one Jeff People. Your Honor, Richard Trush on behalf of Mr. Krueger.
Okay, we're here for a final status conference in Mr. Krueger's case. This is also the plea cutoff. Mr. Trush, have you had a chance to talk to Mr. Krueger about how he wants to proceed?
We have, Your Honor, and we would be prepared to proceed to trial. I would state there was an offer made in this case. So, and I got to find it. I think it was to dismiss the enhancement, but I got to go back and find it. Yes, there was an offer in this that would contemplate plea to count one with the dismissal of the controlled substance second or subsequent offense penalty, as well as the habitual second offender notice. I've discussed that with Mr. Krueger. We would be prepared to proceed to trial. I would indicate, I think we've submitted witness and exhibit list as well as proposed jury instructions. I believe I've received the same from the prosecutor. And I think we submitted, I don't think I've seen it come back yet, but we submitted a stipulation to the court regarding the admissibility of the lab reports.
Okay. All right, Mr. Rolla, are the people prepared to go forward on the 23rd?
Yes, Your Honor, and pursuant to the stipulation, the lab report would be admitted without the testimony of Ms. Mallory Smith. I haven't called her off. My office hasn't called her off yet because we haven't received the sign order back from the court. Mr. Trush gave his permission to sign, I believe it was last Thursday.
Okay. All right, so Mr. Krueger, you've had a chance to talk to your attorney about this?
Yes, sir.
Okay, and you understand that, you know, if you change your mind between now and the 23rd, it's going to be too late, that we're going to go forward from trial if you don't want to go accept that plea offer today. Do you understand that?
Yes.
Okay, so we'll be ready to go on the morning of the 23rd. Mr. Krueger, you need to be here and in the chair next to your attorney by 8:30 that morning, okay?
Okay.
And in the meantime, just make sure that you stay in touch with Mr. Trush in case he has anything he needs to address with you prior to the start of the trial date. This is set for 1 day.
It's actually set for 2, I think, but
I'm probably only going to need one without the lab situation, Judge.
Okay.
I would indicate, I obviously, I think it's set for 2. I would say I'm cautiously optimistic we can do 1.
Okay. All right. Is there anything else we need to address today?
The only additional thing that I would indicate to the court in our jury instructions that we submitted, I submitted a request for the lesser included instruction as well as instructions on possession of methamphetamine as opposed to PWID. I don't know if we're ultimately going to ask for it, but again, we submitted that in our instructions so they would be available.
Okay, thank you. Mr. Rolla, anything further from your side?
No, Your Honor, thank you.
Mr. Krueger, do you have any questions about how we're going to proceed with your case?
No, Your Honor.
Okay, all right, thank you. We'll see you at 8:30 on the morning of the 23rd.
Thank you.
Stay in touch.
Mr. Gallagher, go over to the podium, please. We'll go on the record. People versus Anthony Gallagher, file number 256872. The record should reflect Mr. Gallagher's present here in the courtroom today. If I could have counsel put your appearances on in this file.
The record, Your Honor, like one Jeff People.
Thank you, Your Honor. Richard Trush on behalf of Mr. Gallagher.
This is the date and time set for a sentencing hearing in this matter. Mr. Gallagher, did you have an adequate opportunity to go through the pre-sentence report and talk to your lawyer about that?
Yes, Your Honor.
Okay. Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor, thank you.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
Judge, this is a 5th felony, second controlled substance situation. The guidelines in this case are 0 to 17, up to 10 years. However, in this case, it's my understanding the defendant was on height at the time of the incident offense, and that was with apparently the who also has a long history of substance abuse, as indicated in the PSI at page 1 under evaluation plan. Quote, Although under the guideline range of 0 to 17, there's a presumption of no upfront jail. Under the facts in this case, with the defendant trying to hide methamphetamine in the snow. Also, you have the fact that he had a failure to appear on September 4th, 2025. The court could have scored an additional 10 points under OV 19, which actually would have put the defendant as a D2, 5 to 23 up to 10 years, as opposed to a D1, 0 to 17 up to 10 years. The people's position is the circumstance where the court would not be committing an abuse of discretion and ordering jail time with 40 days credit. Thank you, Your Honor.
Thank you, Mr. Church.
Your Honor, I think the prior history here paints, I think, a pretty clear picture of, what's going on here. And frankly, I mean, as I look at the prior history, I think it's pretty clear what we're dealing with here is an addiction situation. He has several interactions. What's striking to me as I look back at his history, and I mean, the same thing is present here. As I look back at his history, I mean, it largely appears that with the exception of the 2018 Haida case, every single time he's come in contact with law enforcement, it's just been a straight jail sentence. The 2020 possession of methamphetamine case, a 6-month straight jail sentence, fines and costs. 2021, the R&O offenses, disposition, 6 months straight jail, fines and costs. 2023, controlled substance, possession of analogs, straight jail, 9 months, fines and costs. The recommendation here calls for straight jail. It seems to me that this is a clear situation where Mr. Gallagher is struggling with addiction. I think it's clear from his history. I think it's clear from what he's reported. I don't think there's any real dispute as to that situation. His record doesn't seem to be to the point that we should be done investing community resources in attempting rehabilitation, but that appears to be what's been done. I would suggest to the court, certainly a punishment aspect of this is important, and I think it's warranted. However, I really think that we're probably at sort of what I would view as kind of the last stop before we do reach the point where I think the guidelines are going to be such that, again, investing community resources and rehabilitation are probably going to become difficult, if not impossible, right? We recognize that this is going to add 25 points to his PRVs. That means any subsequent offenses are probably going to be at the very least a high-end straddle cell, if not calling for prison. It would seem to me that a more appropriate sentence here may call for some jail up front, possibly holding some in advance, but I would really think that this would be a situation where probation may be effective, or at the very least, maybe give him the option for treatment in lieu of some jail. Again, whether the court, has him serve a little more time before making him eligible or not. But I mean, what stands out to me here is, again, what really appears to me to be, again, on entry number 6 of 6, only one attempt made at, offering community resources for rehabilitation. It would seem to me that it would be appropriate, again, to impose some jail. But I would suggest to the court tempering that sentence with either probation, again, or the option for treatment would be appropriate given his specific circumstances. Thank you.
All right, thank you. Mr. Gallagher, anything that you wanted to say today?
Yeah, I apologize for my behavior, which has caused me to be here today. I understand the substance is a poison and doesn't belong in our communities. My plan to overcome it is by building a strong relationship with my higher power, by attending church, working a 12-step program, and spending as much time with my loved ones as I can. And it's easy to do in jail, and I know the real temptation is until I get out there. But mentally, I feel ready to face that temptation and start the real work, because the real work is out there. That's all I have, Your Honor.
Okay. All right, I did read through the report. I'm familiar with your background and your circumstances. There was attached to this report was a prior PSI from one of your matters in Mackinac County. And that provided all the background and your circumstances. And then this report, of course, had the circumstances surrounding your arrest here and your charges in this case. So I had a chance to review all of that, and I take all of that into consideration along with what you've had to say here and what council's had to say. I mean, it does appear to me that you've had a fairly long-standing substance use issue, and there have been some efforts over that period of time. I know you've been to residential treatment a few times, one time unsuccessful, but I do see that there have been some successes there in terms of completing treatment with relapses, and that's not unheard of. I'm sure you're aware of that. There is a treatment that you've received that relapse is a part of recovery. You know, I'm not sure why there haven't been more probationary terms. You know, just looking through the PSI, it looks like at least one of those, the one after your height of probation in 2020, plea agreement was for straight jail. So I don't know if that was something that, you know, you didn't want to be on probation at that point. Your attorney worked out that deal for you so that you weren't on probation. But that explains why there was no probation in that particular case, at least. It may be because some of your offenses involve assaultive offensive, R&O offenses, which it looks like that didn't occur in this case, but in a number of your other drug offenses, they were combined with R&Os as well. So that may explain the lack of probation. But looking at the circumstances here, I do think that there needs to be a penalty for your behavior in this case, and for your attempts to try and get rid of the substances that you had. And if that hadn't been discovered, now we've got methamphetamine just in the snow, and anybody could come across that, including young children. And obviously you were more concerned about getting those drugs away from you than you were about what could happen if someone, innocent person, happened to come across those and be hurt by them. So I think that justifies a punitive aspect here. I think given the lack of any real ties to this community you were passing through with Ms. Moses, I don't think probation is appropriate in this case either. And I would add that you were on bond at the time of this offense. Again, the inability to comply with conditions of bond doesn't give me a lot of confidence that you would comply with conditions of probation. So for those reasons, I do find that a straight jail sentence is appropriate in this case. The court is going to sentence you to 6 months in the Otsego County Jail. You do have credit for 40 days served. That's in the lower third of the guideline. I think it adequately accounts for your conduct in this case, but also takes into account that aside from leaving the drugs in the snow, this wasn't a particularly serious drug offense. So that is the sentence of the court. I will not have an objection. I don't know if you would be eligible for the work camp program here or not because of your residency, but I will let the jail know that I don't have an objection to your participation in that if you are eligible. You do have the ability to seek an appeal of this sentence. Mr. Trush, could you provide those appellate rights to Mr. Gallagher?
Your Honor, we went over them before Your Honor took the bench, and they've already been provided back to the court.
Right, thank you, Mr. Gallagher. You are remanded to custody of the county at this time.
Judge, are you doing all fines and costs?
I'm sorry.
Are you doing all fines
Oh,
and
I'm
costs?
sorry. Hold on one second. I forgot. I neglected to impose that. The court is also going to impose a crime victim's assessment of $130, state cost of $68, crime victim, I'm sorry, court cost of $325, attorney fees of $350. And then we're also nothing. Is Mr. Drysdale present?
Yes, Chief.
Really? Okay. Mr. Drysdale, you can come forward, please. Court will go on the record. People versus Drysdale, file number 256949. The record should reflect that Mr. Drysdale is present here in the courtroom today.
Thank you, Your Honor. Richard Trush on behalf of Mr. Drysdale.
This is the date and time set for sentencing this matter. Mr. Drysdale, have you had an adequate opportunity to go through that pre-sentence report and talk to Mr. Trush about that?
Dr. Mr. Trush.
Did you need more time to do that before we go forward?
No, sir.
Mr. Trush, are there any additions, deletions, or corrections?
The only correction that I have, Your Honor, is I was retained on this case. So throughout the report, it appears to me as appointed. Also, there's a court-appointed attorney fee that is requested, which I don't think is appropriate.
So we'll strike paragraph 4 of the recommendation. Which is the attorney fee, and then the court will request that the PSI be corrected to reflect that you're retained. Any other corrections?
No.
Mr. Rolla, did the people have any additions, solutions, or corrections?
No, Your Honor, thank you.
And Mr. Rolla, do you have any victims that wish to address the court today?
I do not think it was Walmart, Mr. Chairman.
Anything on behalf of the people for allocution?
Judge, I would indicate apparently the restitution's already been paid. That hasn't been placed out. I asked them to order. This is a defendant who went to Walmart with pre-printed UPC/barcode stickers, which he then placed over more higher priced items and then scanned with the lower price item. This is a situation, yeah, I see that restitution was paid in full on February 9th, 2026. Other than that, Your Honor, I have no further comments from the judge.
Thank you, Mr. Trush.
Your Honor, this is a very, very unique case. And frankly, when I was initially retained on this, I kind of approached this thinking that, we might be dealing with a situation of cognitive decline. As we dived into it more and I got to spend more time with Mr. Drysdale and talk to him, I recognized I don't think that was the issue. I think what was going on here, frankly, was just he had some personal strife that he went through in regards to his marriage and his family. And, as he describes it, I think it kind of made him give up. And, he made no excuses for the actions that he took here. I think he described it as, again, almost like a thrill-seeking behavior. And again, I think that is consistent with what we see, which is up until 2024, I don't think he had any interactions at all with the justice system. And then we see something in 24 and then this year in 25. And again, it's consistent with what you reported to me, which is he had this sort of life event that sort of threw him into chaos. And we see these two events. He reports now that, he's kind of recognized and pulled himself out of this. He's engaged with counseling. He's indicated to me that he is engaged in therapy. He's writing to help him process through some of the emotions and things that have come with the situation with his family. Prior to this, I think Mr. Drysdale is exemplary citizen. He spent his time doing charity work with Habitat for Humanity, building houses down in Florida where he lives part-time. And frankly, he's retired. He was doing community service work to fill his time. He was dedicated to his family. And I think when he lost the family, that was sort of a loss of identity for him. But again, from speaking to him, I think he's taking very appropriate steps, not making any excuses for what he's done. And again, has made restitution and is ready, I think, to take care of the remainder of the fines and costs if that's what's ordered here today. I would suggest, given the circumstances, that would make sense in terms of the resolution. Thank you.
Thank you. Mr. Drysdale, anything you wanted to say?
Just lost my compass of life due to the ex-wife. Jealousy, rage, envy. I have a lot of good times with the young boys, my grandsons. Teach them a lot. And, she likes to drink and I don't. So 30 years went by and no problems, and then all of a sudden she throws. Broke my heart with the grandsons and my daughter-in-law. It's the same kind of personality. I lost. When I went into the jail for the 24 hours, I seen a lot. I seen a lot of young men super sick pills. Most of it's methane. I just can't believe what I saw. Woke me up. I think I have a new direction. I can help people too. I only got so many more years left. So my family's all died from cancer and alcoholism. That's why I stay away from all that stuff. I enjoy my life. I just got a little lost my compass and direction. And I surrendered every time I had to surrender. So I'm proud of what I can do and speak openly, honestly, and surrender every time. Surrendered in 1994, June 4th, in front of with John Phelan, my therapist. She left with another man, and I didn't never bother to, go for my own peace. And I stayed with him for counseling because there was a lot of alcohol use and drug use. Stayed with him for about 15 years. Learned a lot from him. The last, she did this 3 years ago. In the last probably 8 months, it's been a struggle, trying to get that direction. I'm single. I've tried dating, in particular. Everybody wants to do nothing. I have a lot of hobbies, a lot of interests. I love science and art dearly. And I like to teach people, single women. I go and help them with their houses. I try to teach them. I go, why do you teach me? I says, you got to know. You own a house, you got to know. I said, I'll fix it. I'll try and help. It's not much other than I can say than I'll surrender. That's all I can do, Judge.
But I read through the report. This does seem like something that's completely out of your character based on your past history and so forth. And so, number one, I can accept the fact that you had some circumstances that led you to do this that were outside of what you normally would do. And number two, it gives me confidence that this is a one-time thing that you can learn from and move on from. And I'm sure that spending a little bit of time in jail for somebody at your station in life who's never been involved with that before, I'm sure that was quite a wake-up call for you, and it sounds like made the right kind of impression. And at this point in your life, the last thing that you want to do is spend time here in court answering for charges like you were involved in this case. And so I'm hopeful, based on what you said here today, that you are going to take this as a learning experience and something that will influence you going forward and provide a basis for going back to what appears to have been a completely law-abiding lifestyle prior to this.
I've had a good life. I think one of my major causes when I went to therapy and the ex-wife threw the mud, she wouldn't let me air my feelings. I never got to air my feelings because this gal never liked therapy. She didn't want any roles and responsibilities like that. She liked to party and have a good time. With another guy. Like I said, I spent 15 years with John Phelan before he died of cancer. He was a therapist for Boys Village in Oakland County. So he taught me a lot of good things. But when 3 years ago this happened, the therapist wouldn't let me just, you can't say anything. And I never got to air out my whole feelings, about how people are very narcissistic. And I guess I'm the weak link. I'm a happy guy. I like science. I made T-shirts. Mother-in-law's got jealous. I taught the boys how to frame up a house. Nails and hammers. And my one grandson says, "Grandpa, we ride bikes all the time." I said, "I know." And I taught him Hanson lives down in Royal Oak. It was funny, that I couldn't air my feelings out. Tried to tell them that it was eating me alive. Who do you talk to? Another therapist. So I'm going to do therapy again for myself and challenge myself again. But I told Mr. Richter I'm writing, and I'm going to write a book, and I'm going to write it, and I'm going to air my feelings out. The whole family needs to know this, and all that. Kindness matters. And I know I'm a gentle guy, and I don't scream and holler, and I don't fight that way. I fight a fair fight. I was taught, but it's just the mental abuse that they gave me in the last 2 years. Sure.
Well, I hope that you can move on from that, and I think therapy would be a good thing for you. And I hope that you follow through with that.
I will.
In terms of this case, I think the recommendation, which is for basically financial penalties, I think is an appropriate punishment in this case. The court can punish by incarceration, but the court can also punish financially. And I think that is the type of punishment that's called for in this case based on your lack of a prior history.
Thank you.
And so the court is going to impose restitution in the amount of $1,095.01. And does that reflect that? That's
91 cents, Judge.
Sorry, 91 cents.
They don't pay that with us if it's before sentencing. They would pay that with the prosecutor's office, so I don't know if that's
Okay.
been paid.
It's
or
been
not.
paid.
All right. Crime victims assessment of $75, court costs of $325, the DNA testing fee of $60, and a $50 state cost. You do have the ability to seek an appeal of the sentence. If you wanted to do that, you would have to do it within the next 21 days. And Mr. Trush could help you with that if you had more questions. And you may not want to do that, but under the law, I have to say certain things to you so that if there's any question later, everybody knows that.
I just want my true north compass back.
Good, and I hope you find that.
And I've got it here. I can't hold it. And it'll be very clean.
Constructive way is the key there, I think. So
As I was teaching you to. Thank you.
good luck to you going forward. Mr. Trush, Mr. Demick here.
I believe that the court had approved his appearance via Zoom.
Oh, okay. All right, we're a little bit ahead of schedule. We're going to take a short recess and then we'll come back on the record in about 10 minutes.
All rise.
Okay, Mr. Demick, are you able to hear me okay?
Yes, Your Honor.
All right, we'll go on the record. This is file number 256920, People versus Demick. Mr. Demick's appearing today by Zoom by prior approval of the court. If I could have counsel put your appearances on.
The record, Your Honor, Mike Ronald, behalf of the people.
Thank you, Your Honor. Richard Church, appearing on behalf of Mr. Demick.
Bruce, can you tell me the status of this file? I know that you were appointed on this one fairly recently.
I have been, Your Honor. I was just recently appointed, however, from the notice, I could see that it's been adjourned quite a few times leading up to this. I know at least a couple of them were, while Mr. Demick was trying to get screened for appointed counsel, there were some issues that occurred with that process. We're not ready to proceed in a meaningful way today. We're going to be asking for one more adjournment on this. I would indicate, though, we have hit the ground running on this. There's a little bit of investigation that I need to do. However, I've got all the information from Mr. Demick that I need to be able to push that forward. At the same time, Mr. Demick is in the process of exploring the possibility of a veterans treatment court in his home county. As the court knows, the process for a transfer and all that with that can be a little complicated. So again, I know that he's already hit the ground running and made, I got the information to him about the courts. I think he's made the initial contacts with several courts that are geographically in his area. Oakland County has quite a few of them that he may be able to avail himself of. So again, we've kind of hit the ground running, but we're not quite there. Additionally, I am in receipt of an offer from the prosecutor. I do have a counter proposal for him, but again, frankly, I haven't had an opportunity to discuss it with him yet.
Okay. Mr. Rolla?
Yes, Your Honor, there's a plea offer to plead to counts 1 and 2 with $200 reimbursement to the Sheriff's Department for the blood testing. That's the offer of the people. There would be then dismissal of the other 2 counts.
Okay. So I guess Mr. Trush and Mr. Demick, what I would say is this case was bound over, so it's been in my court since October. So we're looking at quite a bit of time where there hasn't been much happening. And so I don't have an issue adjourning today. But to the extent that, a treatment court is going to be part of a resolution here, that's going to need to happen quickly. And, frankly, this case has been pending. It was bound over in October, but it's been pending since I think March of last year, so almost a year. So there's been more than enough time for treatment courts to be investigated and all of that to happen. And Mr. Demick had retained counsel up until this point. So I'm just not going to allow any further delays for the purpose of treatment courts. Those are, again, that's something that could have been investigated and set up. Well,
Your Honor,
Yeah.
my last lawyer didn't.
Eugene, I don't think we need to go down that road. It sounds like the court is going to give us the adjournment that we requested. I think it is in our best interest to say nothing further on that issue.
And frankly, it doesn't matter the reasons. There's been a lot. This case has been pending for almost a year, and there needs to be a resolution one way or the other. So the court is going to grant that adjournment. I just want to make sure that everybody's clear that the court isn't. I'm just not in a position to allow any further delays. So that's where we're at.
Understood, Your Honor. And again, I recognize when I got the file some of that history, and we're not wasting the time.
Okay. All right. So we'll set this for a status conference plea hearing. Mr. Demick, it's important that you continue to remain in contact with your attorney so that we can get things moving. And did you have any questions, Mr. Demick?
Just the last thing was about changing my address because I've been currently living in Oxford, and I don't know if that's something I need to put on the record as far as where, because right now I'm getting the mail's going to my house. My son's living there, so I'm getting the mail sent to me.
What's the address you have? What town?
I have Gifford. It's not Oxford.
Okay, we currently have a Gibraltar address. Did you want that changed?
Yes, Your Honor.
Okay. I'm not going to have you state that on the record here today because we're broadcasting this hearing. So just let Mr. Trush know, and Mr. Trush, we can communicate with the clerk's office and make sure that they have that Oxford address.
Gene, just email that to me and I'll get to the court, okay?
Okay, thank you.
All right, thank you. Mr. Demick, you're free to disconnect at this time.
All right, thank you, Your Honor.
People versus Cornet, file number 256943.
The record, Your Honor, myself, behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Ms. Cornet.
Record should reflect Ms. Cornet's present here in the courtroom today. Second, excuse me. Mr. Trush and Mr. Roll, I was informed by my court officer that there was a distinct odor of alcohol on Ms. Cornet this morning. So I'm going to have Ms. Cornet sit here in the jury box. We're going to administer a PBT. I want to make sure that she hasn't been drinking and that she's in a position that she can meaningfully participate in the hearing this morning. So we're just going to take a break while we do that, and then we'll come back on the record in just a minute.
All rise.
All right, we're back on the record. Ms. Cornet, you did test positive for alcohol this morning. You're not above the legal limit, but it's high enough that I'm not going to proceed with the hearing today until you're sober. So I am going to revoke your bond. We're going to take you into custody, and then we'll reset this for a sentencing hearing at a later date. In the interest of being prudent and making sure that we don't have any appealable issues later, I just want to make sure, now that I know she's under the influence of alcohol, that we only proceed with this hearing while she's sober. Mr. Trush, any record that you wanted to make on
I mean, can the court indicate to me what the level was?
0.04.
I would just indicate to the court, she indicates to me that she has not consumed any alcohol today. I have no additional information for the court. I would suggest to the court, I am available all day if the court wants to address it.
I court railing this afternoon, so we'll have to reset it for a different day. And we have a record of her saying she's not, or hasn't drank, but at a 0.04. And it is what it is. Test doesn't lie.
All this information is new to me.
Yeah, and that's fair. And I want to indicate for the record that Ms. Cornet also apparently was under the influence when she appeared for her interview for her PSI. And then, of course, she was under the influence at the time she was arrested for this offense. So frankly, the positive test here this morning is kind of in line with what's been going on anyway. So that gives me further reason not to doubt the results or think it's from something other than alcohol. Mr. Rolla, any record that you wanted to make? No, okay, all right. So for the record, and I'll issue an order, written order on this too, but Ms. Cornet's bond is revoked for using alcohol during the time of bond for appearing here in court under the influence of alcohol. She'll be held in the Otsego County Jail until we can get this matter reset for sentencing, and we'll notify all parties of the date and time of that hearing. Our next hearing is set for 10:45, so we'll be in recess until that time. Is Mr. Dion's case, is that a attorney general?
We do have an AG is Dion's Attorney General Judge. And I thought there were two, actually. I only see one now. They may have pulled the other one off the docket. But yeah, Dion, Brentley Michael's an AG case.
Right, so we're gonna have to, I'm gonna try and contact them. I don't see them joining in here. So take a quick recess and then we'll come back on record. All right. Ms. Van Wormer, are you able to hear me okay? Are you able to hear me okay there in the jail? Ms. Van Wormer, can you hear me?
All right, go ahead.
Yes, sir, I can hear you.
Okay, and officer, can you tilt that camera up? It got moved down.
Working on it, sir.
Okay. All right, we'll go on the record in People versus Van Wormer. This is file number 205854 and 205855. The record should reflect Ms. Van Wormer's present there in Otsego County Jail. If I could have both counsel put your appearances on.
For the record, Your Honor, Mike Rose, behalf of the people.
Larry Brown on behalf of Ms. Van Wormer.
All right, this is set for a hearing today in both of these files as a status conference. Ms. Van Wormer was arrested on a bench warrant, one that had been issued back in 2023 and the other back in 2022. So Ms. Van Wormer's been absconded from the court for a number of years. So Mr. Brown, have you had an opportunity to speak with your client?
Yes, I have, Judge.
Okay, can you tell me the status of these files here today from your standpoint?
One thing, Your Honor, that I do need to bring up, this is actually a question for Mr. Rolla. It is something that she brought up to me. I did not consider, honestly. She had been requesting drug court. She was denied initially. It would be my assumption that denial would still stand, but if she's if the prosecutor would agree to that, we would want to have her screened for drug court. Other than that, I do have a resolution.
She's not eligible, Judge, because of the absconding.
All right, Mr. Roll is indicating that she would not be eligible due to the absconding.
Thank you, Your Honor, and that was kind of my assumption, but I wanted to make that record clear. There has been an offer in this matter to plead to count 1 and count 2 and file 5854 and count 1 and file 5855 if she could pay restitution of $450 at or before sentencing, which she assured me that she could do that. And that would be for dismissal of all remaining counts and the habitual offense notice in both files. And that is the way I believe we are going to proceed.
All right, Mr. Roll, is that a correct statement of the plea offers?
It is, Judge, and the restitution amount is $450.
Ms. Van Wormer, were you able to hear all of that?
Yes, sir.
And did you want to proceed with that plea agreement here today?
Yes, sir.
Can you raise your right hand, please? Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you. You can lower your hand. Ms. Van Wormer, are you currently on any kind of probation or parole anywhere?
No, Your Honor.
Okay, so in file number 5854, you're going to plead guilty to 2 counts of delivery or manufacture of in count 1 of cocaine and in count 2 of heroin. You understand that each of those counts carries with them a maximum possible penalty of up to 20 years and or a $25,000 fine.
Yes, Your Honor.
And then in file 5855, you're going to plead guilty to 1 additional count of delivery of heroin. Again, that also carries with it a maximum possible penalty of up to 20 years and or a $25,000 fine. Do you understand that?
Yes, Your Honor.
With Mr. Brown or Mr. Rolla, are there any potential consecutive sentencing sanctions here, either discretionary or mandatory?
Discretionary, Judge, obviously because she left, so the court would do that discretionary to any bond violation sentence.
Okay, but no mandatory.
Correct, that's my understanding.
All right. So Ms. Van Wormer, with all of those maximum possible penalties in mind, what is your plea to each of those charges here today?
Guilty, Your Honor.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, I do.
And you understand that by pleading guilty, you're going to be giving up and waiving all of those rights and you won't have them anymore.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've talked about here on the record in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty of each of these crimes?
Yes, Your Honor.
So looking first at file 5855, this goes back to January of 2019. Actually, both of these do. And on or about January 7th of 2019, were you present here in Otsego County?
January 17th of 2019, yes.
January 7th.
Yes, Your Honor.
All right. At that time, did you have possession of some heroin?
Yes, Your Honor.
Did you give or sell that substance to another person?
Yes.
Did you have any legal right to do that at the time?
No.
And then a couple weeks after that, on January 24th of 2019, were you also here in Otsego County?
Yes.
And at that time, did you have some cocaine?
Yes.
And did you also have heroin at that time as well?
Yes, sir.
Did you give or sell both of those substances to another person at that time?
Yes, Your Honor.
Did you have any legal right to give or sell either of those substances to another person?
No.
All right, Mr. Rolla, are the people satisfied with the factual basis?
Yes, Your Honor, thank you.
Mr. Brown?
Yes, Judge.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
You're not, thank you.
Mr. Brown
No, Your Honor, thank you.
and Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Judge.
Mr. Brown?
Yes, Your Honor.
Ms. Van Wormer, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to all three. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, someone from the probation department will meet with you to prepare a pre-sentence report. You'll have an opportunity to go through that with your attorney prior to the sentencing hearing as well. The court is going to order that Ms. Van Wormer remain lodged in the Otsego County Jail without bond pending the sentencing hearing. Number one, her bond's been revoked. She's no longer entitled to pretrial release based on her pleas today, and the court finds, based on her lengthy absconding from the court, that is necessary to ensure her appearance at the sentencing hearing. Mr. Rolla, anything further that we need to address here today?
No, Your Honor, thank you.
Mr. Brown?
Your Honor, just for the record, I did speak with Ms. Van Wormer. I was going to take up the issue of bond based on some things that she had mentioned to me. However, given the court's rationale and current ruling, that is the reason I'm not going to address the issue.
Yeah, there's just, again, number one, there's no entitlement to pretrial release at this point, given the guilty plea. And number two, I don't think there's any argument after the number of years Ms. Van Wormer's been absconded that the court would find convincing enough to release her at this point, because I think there's a reasonable basis to conclude that she would not appear for sentencing. So again, the court has stated its reasons. That's all for this hearing today. All parties on this case are free to disconnect.
Thank you.
Okay, Mr. Burke, if you're there, if you could sign back in, please. Thank you.
Morning, Your Honor. How are you today?
Good morning. And we'll go on the record in People versus Dion. This is file number 256861. And if I could have counsel put their appearances on the record, please.
Your Honor, good morning. For the record, my name is Mark Burke. My P number is 54935. I'm with the Attorney General's Office appearing for the people.
Good morning, Your Honor. Lauren Madison from Harris Law on behalf of Dion, who is standing to my right.
This is the date and time set for imposition of a delay of sentence. And there was a report prepared. And Ms. Madison, did you have an opportunity to go through that with your client?
Yes, Your Honor.
Are there any corrections that need to be made to that at this time?
Just briefly, Your Honor, there was an indication on the report that Mr. Dion does not make upwards of $75 per week. He does own his own carpentry business and brings in about $600.
Okay, Mr. Burke, any objection to that correction?
No objection, Your Honor. Thank you.
Any other corrections, Ms. Madison?
No, Your Honor. Last time we were here, we were discussing the issue of whether, in fact, Mr. Dion had successfully completed drug treatment here in Otsego County. It is his, I believe, sincere belief that completion of that program was supposed to have led to a reduction of that prior felony to a high court misdemeanor. I've been able to find no documentation regarding that. Again, I believe that that was his sincere understanding. We don't have any proof that that is in fact what was entered into, or that that was what even was offered. I suppose moving forward, I would just ask the court to take his understanding into consideration in rendering a sentence.
Well, I appreciate the suggestion, but I can't really do that. I mean, there isn't any record of it. I can't take someone's subjective belief about what they thought as any kind of basis. So
I suppose I would ask more that the court give weight to his successful completion of the drug treatment program, which is verified in his PSI.
yeah, I mean, anything that's verified, I certainly give appropriate weight to. Okay, Mr. Burke, was there any corrections that you needed to make?
Your Honor, to be honest with you, I received the PSI report from the Lansing office, but in a format that I couldn't open or read. So I haven't really actually seen the report. I presume it's fine. I don't even know what the guidelines are. But the one thing I will indicate, and I just want to make sure that we're clear on this. When we were here last time back, I think on January 20th, the defendant took a plea to counts 1, 2, and 3, and the Hab second was kind of put on hold. And I think he needs to plead to the Hab second today. But again, with the understanding that the people are recommending a delayed sentence, and that's what we're still recommending. The defendant did make another payment of $600 in January, which is great. He's making payments. That's what we like to see. That's fantastic. He's making some great progress. So I want to make sure that that's all indicated on the record and to proceed accordingly. I can also give the court an update as far as what the current arrearage is, as well as the defendant's current obligation if the court would like those numbers. So that being said, the people are ready to proceed with the delayed sentencing.
All right, so Ms. Madison, it sounds like there isn't any basis to contest that that this is not a habitual second.
We have no verified reason to contest that, Mr. Honor.
All right, so the court is going to rely on the court records, which do reflect that the habitual second would be an appropriate enhancement. So I think we've got that part of it taken care of. In terms of, and typically for both counsel, I wouldn't address guidelines challenges at this time because this is a delay of sentence. So if there's some reason that we're back for an actual sentencing hearing, then we would address any guidelines challenges. So with that, Mr. Burke, was there anything else that you wanted to state for allocution other than what you've already stated for the record?
Nothing. Well, just a couple things, I guess. The current arrearage that I have as of February 12th is 35,336.03, 35,336.03. The defense current obligation continues to be 521 per month. And the only thing I would ask, I guess, is if the defendant, if Your Honor could, I guess, ask the defendant if about the Hab second, the prior conviction in 2016. I don't know if the court's satisfied with that or not. If the court's satisfied that that's part of the plea, then the people are satisfied. I think normally the court would ask, sir, is it true that in 2016 you were convicted of whatever? I just wasn't sure if the court wanted to go that route at this time. So.
Yeah, I think given the way that we've addressed it for the record, my view is I put the burden on the defendant the last time to come forward with some kind of documentation that in fact he hasn't been convicted of prior felonies and he's failed to do that. So at this point, I'm going to accept what the court records are, which do reflect those prior convictions.
Okay.
So that's how I'm viewing it.
That sounds great, Your Honor. That's fine with the people then. Thank you.
Okay. Ms. Madison, anything that you wanted to state for the record today?
Just briefly, Your Honor, I would ask the court to take into consideration Mr. Dion's successful path that he's been on. I understand we're here before the court on felony charges today. I would ask the court to, in rendering its sentence, and forgive me, I guess procedurally, is it the court's practice to render a sentence that would later be he would actually do later, or like will you give a sentence that he will have to complete today, or that he will have to complete down the road if he doesn't bring the arrearages down? Or is today more about, are we going to enter into this delay?
Sure, fair question. So the way that I address delays is at this hearing, I would state all the conditions of the delay, which would include, of course, paying the child support as contemplated under the plea agreement. If for some reason those conditions aren't complied with at any point during the next 12 months, then the court would set this for a sentencing hearing, at which time I would impose a sentence. So I don't give a conditional sentence on the record today. If it's not completed, then we go forward.
Okay.
We would come back, we would have a sentencing hearing. All parties would be able to once again address any issues with the PSI. Each side would have an opportunity to address any challenges to the scoring guidelines, and then the court would impose an actual sentence at that time.
Okay, thank you for that clarification. I will keep it very brief then. Mr. Dion is an owner of his own business. He's working. He understands the importance of getting those payments done and reducing the arrearages to the greatest extent he can. He's been clean and sober for nearly 10 years. So we would just ask that the conditions of the delay be minimal at this time, Your Honor.
Thank you. Mr. Dion, anything you wanted to say here today?
Your Honor,
Okay, so
pardon me, I
I'm welcome-
apologize.
Sure,
I'm
go ahead.
I'm so sorry. I just got an email from the Lansing office with a PSI that I can actually open and read, which is great. So I just wanted to make one clarification. In the PSI that I'm looking at, it shows the on CFJ 145, page 1. It shows the three counts, 1, 2, and 3. It says maximum, says 4 years, but with the Hab second, I think it's going to be 6 years. I just want to make sure that the record was clear on that. But we're not, naturally, we're still asking for delayed sentence, of course. So because the defendant's great payment history. So
Ms. Madison, any objection to that?
No objection.
I believe that's an accurate correction.
thank you so much, Your Honor.
Yes, thank you for that correction. All right, so Mr. Dion, again, I'm well familiar. It's been a long road to get to this point in terms of the pendency of this case. I think this is an appropriate resolution. I generally think it is in most of these types of cases. Again, the goal here for everybody is to get these amounts paid. And I think this sets you up for the potential of success in doing that. It sounds like you've already been making diligent and good faith efforts to do that so far. So I hope that you'll continue with that over the period of this year. The court is going to adopt as the conditions of the delay, all the terms and conditions in this report. The delay will be 12 months. The court is also going to order, as it's required to do, a crime victims assessment of $130, court cost of $325, a state cost of $204, and a supervision fee of $30 per month during the delay. The court, because, and I do this in all of these types of cases where, again, the focus is on having the child support paid. The court would consider other methods like community service instead of the court cost. So that $325 is something that I could waive in lieu of, you know, a community service or something like that. Unfortunately, the other fees are mandatorily required to assess those. But I'd rather have that $325 again go towards the child support if you would rather do community service instead of that. So I certainly would allow that. Because this is a delay, the court isn't going to impose any jail time at this time or any jail credit. There are also no appellate rights. But Mr. Dion, it's just important that you meet. And is Mr. Brunikel going to be in touch with him?
I instructed him to contact Agent Brunikel.
Okay, so just make sure that you contact Mr. Brunikel to follow up after today's hearing. And I'm hopeful that we'll be back in 12 months with a successful delay and discharge you at that time. Ms. Madison, anything further for the record here today?
No, Your Honor. Thank you.
Mr. Burke, anything further from your side?
The only question I have, Your Honor, is with respect to the delayed sentence review hearing, which would be the actual sentencing in 12 months or 11 months or so. I presume the court will schedule that hearing and just notice it out to the parties and attorneys?
Correct. Yep. We'll provide notice of the date and time of that hearing, probably 30 days prior to it.
That sounds great, Your Honor. Thank you so much.
Okay. Thank you, Mr. Burke. You're free to disconnect. Mr. Dion, good luck to you.
Thank you very much, Your Honor. Thank you, Ms. Madison. Thank you. Have a good day.
Thank you.
All right. Ma'am, are you Miss Euing? Okay. If you want to come over to the table over here, please.
Which one is that?
That one right there. On the record in Euing versus Interior, this is file number 2520223. Yeah, Ms. Euing present here in the courtroom today. Just give me 1 second here. Okay, so the court entered a personal protection order in this case, Ms. Euing, on your behalf.